there's a book or something I can put on it.
A book.
A couple of books.
Down here, it's a problem.
Oh, I know it.
You're right.
Yeah, I'm just thinking.
Guys, really
But you can use that.
Oh yeah, okay, right.
Do you want to Yeah, that's a bit better. Alright, just grab it off me when you're done.
Oh yeah, it's much better. It's not great, but much better. Stephen was doing the introduction of the I'm the last speaker, so I could... Yeah, you shouldn't go as long. No. I'm just doing the brief. So now, where am I?
talk slow. Welcome to the evening show, everybody. This session is called Life, Death and the Law, Queensland 1922. I'm extremely interested in this session, which really does commemorate the events of 1922 by calling them to mind. This session is also the genesis of the whole day's events. The TJ Ryan Foundation, led by its Executive Director Mary Crawford, already had the bones of this session in place by the time I even became aware that the centenary of abolition was taking place. CPJP and I jumped on the bandwagon. Mary and the Foundation were very welcoming and generous, and with the help of some wonderful people and some very supportive organisations, the day and the night came together, which is a long way of explaining that I can claim no credit at all for the enthralling accounts you are about to hear. I will, however, take much pleasure in introducing Dr. the Honourable Mary Crawford AM as your chair of this session. Mary is known to many of us as the member for Forde in the Federal Parliament from 1987 to 1996. Pretty seminal years, looking back. Mary is living proof of the dictum that people with real life experience make the best politicians. Even more importantly, Mary is living proof of my family's motto that teachers make the best people, which is why I became the lawyer. Mary remains and has never not been a teacher, currently practising her craft at QUT. Working up today's events over the last 6 months with Mary, and I can't complete this paragraph without also mentioning Sarah Bradley AO, has been one of the great times of my life. We had one meeting, I think. We hardly ever mapped out what anyone would do. We seem to have just done what was in front of each of us, and somehow it has all come together. For these reasons and more, it gives me great pleasure to invite your chair for this session, Mary Crawford, to the podium.
Thank you very much, Stephen. Good evening, everyone, and I'd like to acknowledge the traditional owners of the land on which we meet. As Stephen has said, the TJ Ryan Foundation couldn't let such a moment go without making some comment on such an important judicial event which impacted on so many lives. This think tank is committed to policy, public policy that changes lives. And the impact of this, I think particularly for those people who have been here today and heard what's happening around the world, is surely something of which we should all be proud. I am also certain too that John Mullen, who was the Attorney General in Queensland from 1920 to 1929, and again from 1932 to 1940, had no idea that we would be talking about him and this legislative act today. I would like to welcome his descendants who are here with us this evening. Can I ask his 4 granddaughters to stand, please? Sorry. And his 2 great-granddaughters. Thank you. We can only hope that the future of public policy is in good hands, and we're delighted you're still interested in it. Can I also say thank you to our speakers for their time and expertise. We believe in research and we believe in solid evidence. Hence, our interest in seeking to understand the climate and the environment that occurred in Queensland in 1922 around the passing of this Act. This is an attempt to discover what can be learned, and what may be still applicable today to policy development 100 years on. I welcome our first speaker, Honourable Dean Wells, our former Attorney-General.
Thank you, Mary. I acknowledge the traditional owners. I acknowledge all the distinguished guests that have already been mentioned. I acknowledge the members of Parliament present in this building. I acknowledge the sacrifices they make in terms of the turbulence of their lifestyle and their proneness to defamation, most of which is undeserved. I acknowledge all those who, because of their human decency, are here tonight. I've just been asked to welcome you to Parliament House. I'm speaking to you very briefly indeed. So this is the welcome to Parliament House. It's a damned impertinence, really, because I don't work here anymore and you own the place anyway. But nevertheless, informally, I welcome you to Parliament House. Back in the old days, we could have given you a more formal welcome. Back in the old days, the formal welcome used to be you were defamed under parliamentary privilege, you were interrogated by the Crime and Corruption Commission, and subsequently you were put on trial by a kangaroo court called the Privileges Committee and held in contempt of Parliament. But we're not going to do that for you tonight. Tonight, this is just the formal welcome. Now, I'm not going to try to add to the intellectual content of tonight's event for two reasons. The first reason is that if I succeeded, I'd just steal somebody else's thunder. And the second reason is if I failed, it would be embarrassing. So I'm just going to tell you a story. If you will, regard it as a bit of local oral history. It was not very long after I'd first become Attorney General that my office received a phone call from a journalist, and they had done all around Australia a survey of what people thought about the death penalty. And a vast majority of people, this media outlet reported, a vast majority of the people wanted capital punishment brought back. And they were asking every state Attorney General what he thought, it was all male at that time, what he thought about the idea of bringing back capital punishment. I said to my relevant staffer, tell them the proposition was that there was more than 80% of the people in Queensland wanted capital punishment returned. I said, tell them it wouldn't matter if it was 100%, I still wouldn't sign the death warrant. Now, I received advice from multiple quarters at that time, tone it down a bit. At the time I was, if I remember correctly, the only Labor Attorney General in Australia. And it was thought that I shouldn't go out on a limb so much. And I said, no. My former Chief of Staff, Susan Moriarty, who's here tonight, reminds me that at the time I said, no, there's some things you don't compromise on. Tell them just exactly what I said. So they did, and we all watched the television keenly that night to see what was going to happen around Australia. And to our surprise, what I said didn't stand out as being particularly radical at all. All the other Attorneys General around Australia had said things like, this is a hallmark of civilization that we do not do this. That kind of thing. They had all said that, even though they were, unlike me, they were not dangerous radicals. They were responsible, respectable people who'd been to the best schools. And so that gives you a little bit of heart, doesn't it? Because the moral of the story is this, that probably every member of Parliament, every person in this place has at some stage had somebody put it on him or her to do something about bringing back capital punishment. There would be hardly a single member of Parliament who had not been approached by the local pub bore with a view that they should do something about bringing back the death penalty. And there would certainly be no Attorney General in Australia who had not experienced something like the little bit of oral history that I just told you. And it's something that we won back in 1922. But we have to win it every day. And the moral of the story, and I timed it just right, the moral of the story is this. I would like to pay tribute to my predecessors and to my successors in this place for the fact that they stood firm every time they were presented with an invitation to return Queensland to barbarism. And if they continue to do that, then long will it be the case that Queensland will remain the beacon to the world that it became in 1922.
Our next speaker is Peter Roney QC. I won't be going through our speakers' credentials because they are many, but also because they are there in the program for you to read yourselves. So without further ado, please welcome Peter Roney QC.
Thank you, Mary. Distinguished guests, ladies and gentlemen, colleagues and friends. 4,000 years ago, people not much different to us came up with the ultimate sanction for human failure to conform, the destruction of a precious life. I've got 20 minutes to examine what has been seen to be the legal justification to begin and then continue for millennia that practice. I've got 20 minutes, so if you would please put up your tray table and make sure your seatbelts are securely fastened, and we will go. At its essence, the death penalty is a sentence for a crime. You've got to remember that. Things were a lot easier for judges in earlier times. There was but one sentencing option for most crimes, death. And as we'll see shortly, the idea of prisons was a relatively recent idea. These days, sentencing for crimes requires the application of legally recognised sentencing principles and objectives, as well as a multitude of mitigating and aggravating factors. Today, courts apply the notion of proportionality in sentencing. That is, the sentence needs to be proportionate to the gravity of the crime, no more, no less. The premise behind the death penalty was disproportionality. The ancient laws of China started before 2500 BC. They comprised the third oldest legal system we know of. Those included the death penalty. Most legal histories trace the first laws creating the death penalty to an 1800 BC code in Babylon, which imposed the death penalty for some 25 different crimes, but murder and killing was not one of them. A life was worth less than, apparently, whether given or taken. These codes applied what we would call today mandatory sentencing, in this case to death for any crime it described. At the heart of them was the idea that governing by punishment created fear, and that being fearful, communities would not commit crimes. The first formally recorded death sentence was in 1600 BC in Egypt, where a member of the nobility was accused of magic and ordered to take his own life. That made it very hard to find a magician for your kid's party for a while after that. By the 14th century BC, the Hittite Code, in what would now be Turkey, prescribed the death penalty. In the 7th century BC, Draco was the first recorded legislator of Athens in ancient Greece. He created the Draconian Code of laws, which replaced the prevailing ad hoc system with a written code to be enforced only by a court of law. Plutarch, writing about this code, pondered that even men convicted of idleness were executed, and those who stole potherbs or fruits suffered just like sacrilegious robbers and murderers. Draconian, we now say. Solon, the Athenian constitutional lawmaker and poet, abolished the Draconian code in the next century, except for the laws on homicide. In the 5th century BC Rome, the 12 tablets created a code which provided for the death penalty, but which differed in its application to nobility, freemen and slaves. It included the death penalty for libel, not so much incentive in those days to become a journalist, one imagines. It also inflicted the death penalty for singing insulting songs. It would take 2,500 years after that before the Sex Pistols had recorded "God Save the Queen, you ain't no human being." In 399 BC, Socrates, that well-known corrupter of the youth of Athens, was convicted and sentenced to death by drinking the executioner's cup of hemlock. The methods adopted in these early periods were often grossly cruel and included crucifixion, drowning at sea, live burial and impalement, even bizarre. In the Roman code, for killing a parent, you could be drowned in a bag with a dog, a rooster, a snake and an ape. For Christians, the most significant execution in history occurred approximately 30 AD outside of Jerusalem. The charge under Roman law was treason and under Herodian law, blasphemy against the temple. The high priest decided that their prisoners should be put to death for blasphemy, but only the Roman governor had that power. Pilate decided he was entirely an innocent man, but eventually gives in to the mob for political expediency. If the plan was to stifle interest in that fellow by his execution, it was a very poor plan indeed. Talk about unintended consequences. Some 300 years later, the Roman Emperor Constantine abolished many cruel death penalties, but a century later, under the Christian emperors, the laws of the Roman Empire were codified. The code had at least 80 offences which attracted the death penalty. I'm going to turn to English law and the death penalty there. The death penalty laws in Australia came from British law, that's why it's important. The death penalty came late to Great Britain, when in the 5th century hanging was first introduced as the main form of execution. The use of the gallows continued for 550 years. In the 11th century, William the Conqueror, a man with a bad reputation for cruelty, actually abolished capital punishment for all. Then his son Rufus, who did not inherit his father's sensitive nature apparently, then reintroduced it. Usually those sentenced to death were executed by hanging. Often they would be grotesquely tortured during and even after their deaths. The execution would often pull out the living man's intestines with a burning corkscrew, and the intestines set alight and left to slowly burn before mercifully and eventually the heart was cut out. The last such punishment occurred in Britain only as late as 1820. That and many other atrocities were committed in 1660 in front of a large crowd on the hanged but kept alive body of John Cook, the barrister who took the brief to prosecute Charles I for crimes against his people. For taking that brief, he was found guilty of treason. After he was subjected to this, the stench of putrefied, burnt, rotting intestines was so horrific, so horrid that the residents of Charing Cross in London petitioned the King that there should be no more executions that day. Cook was famous as a barrister who invented the right to silence. He invented the cab rank rule and the duty to act free of charge for the poor. Ironically, he had argued for restrictions on the use of the death penalty. Under Henry VIII, more than 72,000 were put to death. These included by grotesque methods such as being boiled alive. During the 18th and 19th century, British law put the age of criminal responsibility at just 7 years of age. We're dealing with children. Mandatory death sentences had to be passed on 7 to 13-year-olds convicted of minor crimes, although many were routinely commuted. In March 1716, a 12-year-old boy was hanged for housebreaking. In 1750, a 17-year-old illiterate girl went to the gallows at Tyburn for publishing a forged will. It was not until the late 1900s that the execution of children was abolished in Britain. The death penalty for pregnant women was only abolished in 1931. The existence of another life in the equation did not apparently matter. In the century before British settlement here, under the Bloody Code as it was called, more than 200 crimes were punishable by death in Britain. These included such trivial things as robbing a rabbit warren or even felling a tree. These laws attracted the censure of Sir William Blackstone, noted jurist, who noted in his famous commentaries of 1765 that applying the same punishment to crimes of different severity was a kind of quackery in government. The first prominent European to call for an end to the death penalty was an Italian, Beccaria, from Milan. In 1764, that is only 26 years before the penal colony of New South Wales was established, Beccaria published his famous essays on the reform of the criminal justice in 18th century Europe. It was the first call for the abolition of capital punishment in its entirety. Beccaria's book influenced a large number of prominent British lawyers and jurists, including William Blackstone, that I've just mentioned, and Jeremy Bentham. In England in 1808, Sir Samuel Romilly succeeded in abolishing the death penalty for lesser offences. He told the House of Commons that it was an outrage that there was no other country on earth that had so many different offences punishable by death as England. A dramatic change in sentencing options had come in the 1700s with the arrival of institutional publicly operated prisons. For the first time, you could impose long jail terms on lots of people. Before then, the only available units of measurement for serious crimes were degrees of deviation from an ordinary execution. In 1823, British law for the first time gave judges a discretion or a power to impose a sentence other than death in appropriate cases. There were still then over 200 offences which carried a mandatory sentence for death. This law was also adopted in colonial Australia soon after. By 1868, the law had ended public executions in Britain. The English criminal law and the death penalty were brought to Australia by the creation of the penal colony in New South Wales in 1788. The colony had jurisdiction to deal with more serious offences according to the laws of England. Hence, a very substantial number of crimes attracted the death penalty in the new penal colony, something like 160, and by the early 1800s, even more, 220. In July 1825, then Governor Darling was given legal power to order and carry out, or not carry out, as he saw fit, executions for offences other than murder or treason. In the 10-year period to 1836, the New South Wales Supreme Court imposed death sentences on almost 1,300 prisoners, of whom 363 were killed. In 1830, there were more executions in New South Wales than the whole of England and Wales for the same year, and I'll explain why in a moment. In the 1800s, in some years, up to 80 people per year were executed in Australia. The numbers rapidly fell as the century progressed. One reason for this falling number of executions in Britain between 1780 and 1868 was that transportation to Australia and America and other places could happen. The British state had long been searching for alternative secondary punishments for capital offences. The crime rate had not slowed despite the longevity of that penalty. From then, less than 20% of convicts sentenced to death were executed. In 1838, New South Wales repealed capital punishment laws for most crimes, but not all. In the mid-1850s, local newspapers began to record public feeling developing against all forms of capital punishment. The press began to give a critical view of the voyeuristic and brutal elements of the hangings that were still occurring. Let's turn to Queensland. Until December 1859, when Queensland separated from New South Wales, it was of course part of and subject to New South Wales law. Just prior to separation in 1853, the New South Wales Parliament proclaimed an end to public executions. It took 2 years to be given effect as law. Despite that, there were still public executions, and in Moreton Bay in 1855, 2 Aboriginal men were publicly executed in front of other Aboriginal persons, some of whom had been made to watch. The Queensland legal system would lack a way to appeal criminal matters or judgments, verdicts for the next 50 years. A death sentence was carried out even for unsafe verdicts, which today would be set aside. The establishment of an appeal court only happened in 1913 when the Supreme Court became a court of criminal appeal. In colonial New South Wales, the Executive Council consisted of various government officials appointed by the Crown, including the Chief Justice. The Council had power to commute death sentences. Altering the death sentence by way of a prerogative of mercy did not, by letter of the law, reverse the decision like our modern Court of Appeal decisions might. Given the lack of appeal options available to colonial criminals, the Executive Council functioned imperfectly as the nearest thing to a court of criminal appeal. So also in Queensland, the dispensation of executive clemency played an important role in the administration of the criminal law generally, and Professor Mark Finnane will tell you more about that shortly. Prior to the enactment of the Queensland Criminal Code in 1899, which applied from the start of 1901, the criminal law of Queensland provided for mandatory death sentences following conviction on any charge which attracted that penalty, and there were many. After the Code in 1901, only treason, willful murder, piracy and attempted piracy with violence potentially attracted the death penalty. In fact, 4 years prior to Griffith's Criminal Code being introduced in 1899, the practice of carrying out the death sentence had entirely stopped in practice. Griffith himself, though, appeared to support capital punishment, at least for some serious crimes. In a case of the kidnapping, enslaving and murder of Pacific Islanders by those on the ship Hopeful, the second mate was sentenced to death. Griffith was only one of two who opposed the commutation of it in Executive Council. Once the Code came in on a conviction for murder, but not willful murder, the trial judge could refrain from pronouncing the death sentence and to have the sentence merely recorded. This was code to the executive. The trial judge considered that the death sentence ought to be commuted to a term of imprisonment. In 1899, the Code had redefined the classes of capital punishment, but did not abolish it entirely. That, of course, was the bill for that code. It was left to Joe Lucena in 1899 in the Legislative Assembly on the second reading of the bill to argue that it should be abolished. It's hard to imagine that he did so without advance notice to his Labor Party colleagues then in opposition, but they didn't support him. Lucena was elected to the Legislative Assembly for Claremont in that year, in 1899, and served until April 1912. He never rose to any particular position of power or influence in the Labor Party, but his actions led to the adoption by Labor in 1910 of a formal policy for the abolition of capital punishment. This played out 6 years later, as we'll see in a moment. In 1899, Rutledge, later a QC and a judge, as the then Attorney-General, warned Labor members not to attempt to limit capital punishment to any greater extent than the Code provided for. But he tempted them with reform and the use of solitary confinement, and the use of irons in prisons and in corporal punishment, that is, reforms in those areas. On the second reading of the bill, the Code Bill in 1899, Lucena took the solitary position of insisting on abolition for all offences. He began his address to Parliament by illustrating the gradual reduction in the number of capital offences that had been taking place throughout the previous century. He pointed to the European states where total abolition had not caused any marked increase in crime. Murder, he said, was just as much murder when authorised and directed by the executive as when it was committed in cold blood by a private individual. The Labor Party didn't support Lucena then, probably thinking it a hopeless case, but also one which would make it harder to get more attainable kinds of penal reform. The election of the T.J. Ryan Labor government in early 15 led to an attempt in 1916 by Labor, now as the government this time, to abolish the death penalty by amending the Code. One of the stated justifications was to remove from cabinet members the disagreeable task of having to decide if people should hang or not. In 1916, in the debates, the 1899 speech by Lucena was read out in the debates by the Dalby solicitor, Vowles. He said the arguments used against Lucena by the Attorney-General in 1899 still applied. The law was passed in the lower house but rejected in the soon-to-be-abolished upper house. Professor Saunders will pick up the rest of this story for you. Modern legal theory on sentencing focuses on theories of punishment and, more recently, sentencing objectives. Among legal theorists, there are typically identified two broadly different ways of thinking about the moral merits of punishment, to address serious criminal misconduct at least. Justifications on sentencing are proposed either with reference to backward-looking considerations or forward-looking considerations. The backward-looking considerations look back to the offence committed in order to link directly the amount, kind or form of punishment to what the offence merits as a penal response. This linkage is often characterised as to whether a punishment fits the crime committed. This goes back to the earliest ideas behind the use of the death penalty. In simple terms, this was an eye for an eye theory of punishment. Looking forward, justifications assess the future effects, the benefits or consequences of capital punishment, such as crime prevention, or deterrence, incapacitation and rehabilitation. One novel example of this occurred in Queensland in the 1916 debate to amend the Code. That was that keeping the death penalty avoided mob rule, who would impose their own penalty. That is, if we don't kill them, the mob will. As for deterrence, the legal system accepted that the object of capital punishment is to alarm and deter persons predisposed to crime from even committing it. We now know that most murder offences are committed without any premeditation. There is considerable research to show that the death penalty is no more effective than imprisonment in deterring crimes of most kinds. We know that in Australia, as the 5 states abolished the death penalty, murder rates did not increase. The second justification in law that I've mentioned is said to have been incapacitation for the commission of further offences. Obviously, the death penalty provides the ultimate incapacitation. Ironically, focusing again on murder, we know that the rate of reoffending for murder is the lowest of all offences. Turning to rehabilitation, modern sentencing policy significantly focuses upon rehabilitation of offenders. Necessarily, capital punishment denies the prisoner any chance of rehabilitation. Criminologists now know that even the worst, most violent criminals, persons who apparently have nothing to commend themselves to the community, are capable of rehabilitation and can make useful contributions to society and be deserving of dignity. The denial of that opportunity for a second chance, even for the worst of criminals, was a travesty of our legal system for as long as it happened. And worse, the death penalty didn't even work. The denial to convicted persons of a chance to be exonerated discredited the legal system. The announcement 3 months ago in this state of an inquiry into the inadequacies of DNA testing and the evidence used in criminal trials here since 2012 is a warning that even today elementary mistakes can be made that can result in false verdicts. And with that thought, I leave you.
Thank you very much, Peter. Our next speaker is Professor Mark Finnane from Griffith University.
As Peter's indicated, I'd like to follow up his overview of the law by talking a bit about the administration of the law, of the death penalty regime in Queensland. So the history of the death penalty in Queensland is a history of hanging. The hangings were notionally private, that is, within the walls of a jail. But in Queensland, the practice persisted for some decades of making these public events by bringing to the event large numbers of Aboriginal or Islander prisoners to send the deterrent message that execution was meant to convey. Occasionally there were people who suggested methods other than hanging. Take a correspondent to the Brisbane Courier in April 1892. Will you permit me to suggest a system of execution which I have never seen advocated, but which to my mind at least appears far preferable to hanging, decapitation, garroting, or this newfangled electrocution. In the place of these methods, the correspondent wrote to the editor of the Brisbane Courier, I would cause death by asphyxiation with carbonic acid gas. Death would then be rapid, painless, and unaccompanied by disgusting concomitants. Abolition clearly came too early for some advocates of more modern methods of execution. In self-governing Queensland, between 1860 and 1913, 81 men and 1 woman were hanged after their death sentences were confirmed by the Executive Council. They were the unfortunate ones. We might say that they failed to benefit from a number of steps that made execution after a judicial death sentence a less likely outcome than reprieve. A couple of facts. Over these years, from 1860 to 1922, 218 men and 6 women were sentenced to death in the Queensland courts. The majority of these had their sentences commuted. A handful had convictions quashed or were pardoned. Over these same years, more than 1,000 people were charged with murder or rape. Of these, more than a quarter benefited from the withdrawal of the prosecution from a nolle. More than a third of them were acquitted. So the majority of those charged with capital crimes in Queensland never faced a judicial sentence. But these patterns were racially inflected. Nearly 6 in 10 Aboriginal defendants were convicted, while the same proportion of non-Aboriginal defendants was acquitted. I want to return to this difference. A regular business of executive government from 1860 was the consideration of the death sentences on those convicted of a capital crime. The decisions, as we've heard from Peter, were made by the Executive Council, the Governor in Council, the Governor sitting with and advised by his ministers. They were commonly assisted by the judge at trial, who might report recommendations of the jury, as well as any other matters bearing on the possible exercise of mercy. Processing factors noted in one of the earliest meetings of the Executive Council in 1860, attended by the then single judge of the court. The minutes record only that Justice Lutwich read the report that he had been requested to make on the conduct of the trial before withdrawing. The council, quote, "After mature and anxious consideration of the whole circumstances of the case, then confirmed that the extreme penalty should be carried out on Friday, the 7th of December." Unquote. In the vast colony of Queensland, it was not always possible for a judge to attend in person, and so the archives contain a very valuable record of the considered comments of Northern Court judges like Edmund Shepherd, to whom I will return. In the memorialisation of the death penalty, in the way we talk and think and see evidence of it, most attention is paid to the executed. Now, the focus on the hanged, of course, is understandable, but I want to draw attention to the death penalty regime in practice, the question of victims' justice, the process of decision-making, the role of racial and gender considerations, and political ones. To appreciate the degree to which hanging was a lottery, which was one of the most potent objections to it, we need to appreciate the elements of mercy, process, and pardon in the death penalty regime. So how did Queensland compare to other colonies? Viewed beside New South Wales and Van Diemen's Land, in Queensland, hanging was an infrequent event. As we've heard from Peter, there are almost 1,000 executions in New South Wales, 545 in Tasmania, almost all of these in the convict period. The convict era was notoriously brutal in some of its phases. In the first 40 years, 2 out of 3 of those sentenced to death were executed. After 1850, however, the rate of execution in all places in Australia was around 1 in 3, as in Queensland. The most challenging fact of the Queensland death penalty was the racial disparities in the story. Quite simply, Aboriginal defendants sentenced to death were more likely to have their sentences commuted by the Executive Council. The execution rate for capitally convicted Aboriginal prisoners was less than 25%. For others, it was more than 40%. But this paradox suggests that this isn't the whole story. And to understand why, we have to consider the offences for which defendants were charged. Originally, there was a wide range of capital offences. The Queensland death penalty was almost entirely reserved for murder and rape. On these capital charges, there were more than 1,000 trials after 1860. Nearly 1/5 of these involved Aboriginal defendants. Now, these defendants were less likely than others to benefit from a nolle, from the withdrawal of the prosecution. They were somewhat more likely to be found guilty by juries. Once convicted, they were more likely to be sentenced to death. But at Executive Council, they were more likely than others to be reprieved. But this also is not the whole story. The most important distinction between the experience of Aboriginal and non-Aboriginal defendants lies in the fact that capital trials included the offence of rape as well as murder. Colonials justified the retention of the death penalty for rape as a necessity for the protection of white women. In 1865, the Attorney General in this place, Sir John Bramston, opposed the removal of rape from the capital statutes. I quote him, "Capital punishment will be kept for rape because the women in this colony are in a more defenceless position than at home from our limited population and scattered habitants. They are liable to assaults from the Aborigines. For the Aborigines," he said, "I believe that hanging is the only thing that brings home to them the terror of the law," unquote. Many judges agreed with Bramston, though some did think that imprisonment would be a more effective deterrent. But until the commencement of the Criminal Code in 1901, rape remained a capital offence, although there were no executions after 1892. Not all those convicted of rape were executed. 40 convictions for rape involved defendants identified as Aboriginal. Of these, 20 were sentenced to death and 10 were ultimately executed. The contrast here is with the way in which non-Aboriginal defendants were dealt with by the Queensland criminal justice system. There were 201 convictions of others, of whom only 19 were sentenced to death and 4 executed, 3 of them Pacific Islanders. The heavy toll of executions of Aboriginal people on conviction for rape was the end point of disadvantage throughout the criminal justice process. In the period when the penalty for rape was death, less than 1% of settlers accused of the crime were put to death. But before this, the scales of justice already weighed heavily against Aboriginal defendants accused of rape. The discretion of the Crown to return a nolle was almost never exercised in a rape case involving an Aboriginal defendant. And on a charge that legal professionals and politicians repeatedly intoned was easy to make and difficult to prove, 3/4 of Aboriginal defendants on a rape charge were convicted, versus 1/3 of settlers. From this perspective, historians have severely criticised the racism informing the Queensland judicial and political systems. Jury exoneration of settler defendants facing rape charges was rampant in Queensland, as in other parts of Australia. But for the most part, police, prosecutors and judges performed as poorly as their juries. The contrast is highlighted when we compare the treatment of those convicted of rape with the other main capital offence. Only 5 of the 43 Aboriginal defendants convicted of murder and sentenced to death were subsequently executed. We may look at these facts in another light. In respect of First Nations peoples, the Queensland death penalty system performed poorly on a fundamental test of justice, that of the protection afforded to victims. While 5 Aboriginal female victims were among those identified in the 241 rape case tried, 4 of them alleging the offence against a non-Aboriginal man, not a single one benefited from a conviction. On this record, perhaps the most telling commentary came from an Aboriginal man sentenced to 15 years after pleading guilty in 1896 to an attempted rape on a white woman at Tamborine. Asked by Justice Cooper if he had anything to say before sentencing, the response was devastating, and it's reported in the Brisbane Courier. Quote, "Prisoner replied that white men treated black women in the same way and said the white men took the country from the blackfellas. The blackfellas should have the same rule as the white men," unquote. 1896. This challenge to the system was a view shared, in fact, by many judicial officers and legal counsel. So in the story of the Queensland death penalty, there are some moments of redemption. One has been the recent use of the prerogative in extraordinary retrospective pardoning of Kipper Billy, who's co-accused for rape and sentenced to death in 1862, but subsequently shot while trying to escape from prison. A determined campaign of historical redress by journalist Ken Blanche a few years ago resulted in a recommendation to pardon, which was accepted nearly 160 years after his death, and after the executive pardon which had been granted in April 1862 to his co-accused. A few years later, an Aboriginal man, Jemmy, was saved from execution by the quashing of his 1865 conviction for rape. Such an outcome reminds us that the death penalty regime was administered within a framework of criminal law that had its own procedural standards. In 1887, Jacob Stevenson, described in reports as an American Negro, was pardoned by the Executive Council after his conviction for rape. Attention was focused on his case as a possible miscarriage of justice after a petition of more than 2,000 people testified to his character. These were exceptional instances, however. Most commutations resulted from the application of a calculus of harm and culpability. Decisions, as I've suggested, were inflected by racial considerations about victim identity in the case of rape as well as murder. How far could the judiciary shape outcomes? A decision to award the sentence of death recorded was one signal that judges could send to Executive Council, always resulting in commutation. Another was their evaluation of the fairness of the trial and decisions of the jury. From Bowen in the 1870s, Justice Shepherd showed a serious professional concern with the responsibilities of his office when he returned this report to the Executive Council. In 1877, he successfully urged the commutation of death sentences on 2 Aboriginal men convicted of rape on a 12-year-old girl. He was exercised by the failure of the jury to add a recommendation of mercy. On the facts of the case, he believed such a recommendation would have been added in the case of a European accused. He later successfully persuaded Executive Council to commute the sentences on 2 other Aboriginal men convicted of murder. And his comments to the Governor in the minutes sent from Bowen to Brisbane were blunt, and I quote, "The administration of justice with regard to Aboriginal blacks is surrounded with great difficulties, and it is particularly so in the north of Queensland, where no doubt a prejudice exists against these people. Juries, I think, involuntarily bear rather hardly against Aborigines placed upon their trial," unquote. Beyond the judiciary, there was also outside opinion bearing on the Governor and his ministers. The case that Peter has mentioned of the sentencing of the Blackbirders, McNeill and Williams in 1884, resulted eventually in Executive Council, after first inclining to confirm the executions, changing their mind and commuting. This was in the face of opposition of the Premier, Samuel Griffith, who condemned the convicted men for their role in what he called a voyage of murderous atrocity, and it dismayed Governor Musgrave, who, quote, condemned the view that the life of a black human being was not as sacred as that of a white man, unquote. Musgrave's reluctant signature to a commutation reminds us that by this time, responsible self-government meant the Governor must follow the advice of his local ministers. So let me conclude these comments, which have drawn attention particularly to the racial disparities of the death penalty regime in Queensland, with these thoughts. In self-governing Queensland, the administration and abolition of the death penalty is a story that cannot be readily captured in condemnation or satisfaction. As in other Australian jurisdictions at this time, a majority of those sentenced to death were saved from the gallows by clemency decisions shaped by political considerations, as well as racial prejudice and gender assumptions. If the death penalty was a measure of justice due to victims, many of those were denied such justice. In a criminal justice system that frequently lacked adequate professional safeguards, the death penalty also denied fairness to some, at least, of the hanged. But a final observation: the racial politics of the death penalty in Queensland in the late colonial era suggests this thought. that what made it possible for Queensland to surrender hanging as an instrument of law was the security of Queensland in the achievement of a white Australia. After 1897, the Aborigines were protected, that is, controlled almost entirely. After Federation, the Pacific Islanders were excluded almost entirely, and the immigration of non-British people was strictly controlled. A federated Australia introduced the Queensland Criminal Code with its death penalty into the administration of Australia's colonies, resulting in continued executions in Papua New Guinea long after the Queensland abolition was achieved in 1922. In this context, I think it is worth remembering that abolition of capital punishment was just one of 8 abolitions in the Labor federal political platform adopted in 1919. The platform whose first objective was, and I quote, "the cultivation of an Australian continent, the maintenance of a white Australia, and the development in Australia of an enlightened and self-reliant community," unquote. That context must qualify, I think, any sense of self-satisfaction we might feel about the early abolition in Queensland. Thank you.
Our next speaker is Professor Kay Saunders.
As we've seen, Queensland held a unique place both in the Australian Commonwealth and in the British Empire by its use of the abolition of the death penalty in 1922. Queensland was also unique, as has been pointed out, that it did not have public executions because we didn't become a separate colony until 1859. So if we look at Queensland in the context of other colonies, New South Wales did not abolish capital punishment until 1985. That is well within our lifetime, although I might say it did not have an execution after 1939. And in Western Australia in 1964, the serial killer Eric Cook was put to death, and of course Ronald Ryan, the most famous case that we'll see the book later, in Victoria in 1967. So my address will look at the factors that led to this extraordinary human rights initiative. Queensland, interestingly enough, did not possess a movement to abolish the death penalty in the 19th century, and in this it's quite unique amongst the eastern colonies. Now you'd think these things don't go together, but in fact, as I'll show, they do. The anti-abolition or the abolitionist movement starts in Tasmania in 1842 when Nathaniel Kentish writes an essay on capital punishment, though it's most effectively addressed by the Tasmanian public librarian who had his job for 47 years of all things, Alfred Taylor. Now, he's a fervent abolitionist, and his father had been a felon in Van Diemen's Land, and he may have seen, or at least he would have heard of, the most appalling events that occurred in Van Diemen's Land as it was then, because there was the gibbet, and outlaws and bushrangers could be decapitated and have their heads put on what is now Salamanca Place and left there to rot. And in fact, outside of Launceston, there is still a place called Gibbet Hill, though not, I might add, a great tourist attraction. In New South Wales, where a lot of the actual activity occurs, was led first by a most remarkable liberal-minded pastoralist. Normally, liberal-mindedness and pastoralism didn't go together, but in this case it did, with Terence Murray, who was both the Speaker of the New South Wales Legislative Assembly and later he was the President of the Legislative Council. And he was one of the drivers to oppose convictism and to set up a responsible government, which came in New South Wales in 1856. Early in 1859, that is, that's not long had responsible government, he puts in a private member's bill to abolish capital punishment. It doesn't go anywhere. The next person who takes up a private member's bill was Henry Parkes, who of course was later very important in the Federation movement. Again, it's the activity of a lone member. It gets no traction whatsoever. And then again in the mid-1860s, one of the founders of the AMP Society, Frederick Lee, he's Jewish, he's very conversant, he's a Talmudic scholar, he's very conversant with ancient Hebrew, and he starts a debate about what we would call the Old Testament actually say about murder and punishment, and of course points out that in the Cain and Abel story, Cain doesn't get executed, he is merely exiled. But then of course exile was the place that New South Wales became for convicts, so you have a slight anomaly there. New South Wales was also in the forefront later in the century when a bill was debated twice in the lower house, and without, I should say, much enthusiasm, but it was debated, and it was passed that New South Wales would abolish the death penalty. However, once it went to committee, it languished and it didn't even go to the upper house. Why this happened is hard really to know. There's not a huge amount of commentary in the newspapers. Queensland only produced one obscure pamphlet entitled The Cavalry of Superstition or the Downfall of the Scaffold, an essay on capital punishment, and it was published here in 1886 by a very eccentric journalist, John Camille Wheel, who is later known in the newspapers only for his convictions for being a denizen of Chinese opium dens. You can read it on the National Library. It's a very strange document, but you can read it on the National Library pamphlets and rare book collections. Unlike Queensland, as I'm going to show, the earlier movement, which was largely New South Wales and Tasmania, and to a smaller extent in South Australia, was led, as you could imagine, by clergymen and very educated people who could read Greek, Latin, and in some cases Hebrew. And a lot of their arguments showed that they were fully conversant with the reforms that were occurring in Italy, where the death penalty had been abolished, although mandatory life imprisonment and being put in a cell by yourself is not exactly a nice alternative, and by the progressive American states like Wyoming and Rhode Island. What happened in Queensland was it was largely through the actions of the Labor Party, although, as I'm going to show, it's not done with any great enthusiasm or passion. And the story of how it occurs, I think, is quite an anomaly. As Peter Roney has shown, in the 1899 debates on the Criminal Code Bill, only the maverick Labor member for Claremont, Joe Lucena, spoke in favour of the abolition of the death penalty. He was later the first MLA in Queensland to raise the question of the abolition of the Legislative Council in 1906. However, Lucena is eccentric, he is not a team player, he comes out with these things without discussing it with his colleagues, and he's not really a very popular member of the incipient Labor team. Like Weir's pamphlet, he relied very much on the works of Victor Hugo rather than go through a law about the criminal process. It's rather a very emotional Les Miserables argument rather than a legal argument. Now, one of the things when I was doing this research that I realised was important, I actually started it by reading the debates first, and the case of James and Patrick Keneath was brought up. And so I wondered why this was brought up in the 1916 debate. So I realised that I would have to go back and do some research on the Keneath case, because obviously it was an important accelerant in the movement towards abolition. Now, if I can tell you, they are called our last bushrangers, the sort of the northern Ned Kellys. There were two brothers, Patrick, who's the elder one, and James. And in 1902, now these men have been seen often, and if you read books on bushranging, they're portrayed as manly, men fighting for the poor farmers and workmen. They were actually standover merchants, thugs, sadists. Why they're important and why people supported them? Firstly, they're young and they're handsome. Extremely handsome. Yes, I think that, if they'd been buck-toothed and ugly and scrawny, no, they're handsome. The other thing, of course, is that they're poor Irish Catholics. So particularly in the Labor movement, there's a lot of sympathy for poor Irish Catholics. And we can see how much sympathy there was in the community after very brutal killings of a constable and, of all people, I don't know why he was even on this expedition, but the station manager of Carnarvon Station. The government put out a reward of £1,000. Now, an average worker would take maybe 5 years to earn £1,000. Not one person came forward. And once they had killed, there's an escape, so it's a large area, and people would have known, like the Kellys, they would have known, but no one dobs them in. The preliminary hearing was heard in Rockhampton. The Keneaths were represented by the newly admitted barrister, T.J. Ryan, who was at that time the classics master at Rockhampton Grammar School. He challenged the Crown Solicitor's case over a proposed use of a special jury of only 4 people instead of 12, because the government realised if you had a trial in Rockhampton with 12 peers, the likelihood that either James or Patrick would be convicted was probably fairly slight, I would think. Ryan performed very well, although he was hampered by not having access to the Crown's case, which, yes. So I think we can see already there's a story that there's going to be some political interference in this case. It was then decided that the trial would be held in Brisbane, and it was held in front of a jury of 4 professional and businessmen who had been carefully picked. So Samuel Griffith, the Chief Justice, was on the bench. Now later, of course, this whole issue that this was not fair, that under common law you should be judged by 12 members of your peers, was of course a leading example of what was seen as the politicisation of this case. there were other irregularities, I mean gross irregularities in the case as well. The accused were represented by two solicitors who were completely out of their depth. They're not barristers, they hadn't done trials, and certainly they hadn't sat on a capital crime. And the Crown had Edward Lilly and Lionel Lucan, who was later a very distinguished member of the Supreme Court of Queensland. The evidence with the case, the murder case, is highly circumstantial. Neither of them ever confessed, and the Aboriginal tracker who was accompanying Constable Doyle was off chasing a lost pony. So he only heard the shots, but he didn't see it. However, I would have to say in this case, with 200 pounds of charcoal in their saddlebags that had a lot of human remains and items that belonged to Doyle and the station manager, might indicate a degree of guilt. The other extraordinary thing in this case, which I'm still astounded by, is that when Chief Justice Griffith was giving his summing up to the jury, the Premier, the Conservative Liberal Premier, Sir Robert Philp, who had set up Burns Philp, which was the company that had his ships were involved in the hopeful case of the kidnapping, and they also had the contract to deport the Melanesians in 1906. And he's extremely concerned. He comes to listen. Now, the Premier is not a private citizen. Many of the wealthy businessmen of Brisbane also came along to hear Griffith's summing up. Now, I think, yes, I don't think I'm stepping the mark to say this is overtly political. The jury decided, gave a guilty verdict, and Griffith gave, of course, the death sentence. Now, at this time, there was no formal appeal process. This doesn't come in until 1913, as we have seen with Peter's paper. But what happened under the criminal code, the Chief Justice, you could have a review of a case by the full court, which occurred in this case with 4 members, including Griffith, sat on a full court review of the case. Now, what happened is that one judge, Judge Reel, thought that James, who the evidence is not quite as firm towards, was perhaps not guilty. And so his sentence is commuted to life imprisonment, of which he serves 14 years for good behaviour. And Patrick is executed. Now, Lucina now enters our story again. He led a huge public outcry, particularly in regional Queensland. The Labor Party relied a lot on its votes up north and out west. And there is a huge campaign of public meetings, of petitions, etc. On the day before Patrick's sentence was to be carried out, on the 12th of January 1903, over 4,000 people held a vigil in Brisbane despite a cyclonic outpour. And this, I think, this moment marks the beginning of our abolition movement. The following year, with the imminent, though it was commuted, execution of the MacDonalds for the torture and murder of their disabled daughter, the Labor parliamentary leader at the time, George Kerr, member for Barcoo, expressed an aversion to capital punishment. No one else does. It's sort of just mentioned in passing. And nothing is done, and of course there's no, in a case like this of filicide, there's no public outcry. tentative Labor endorsement for abolition was unsuccessful in 1907, the year that witnessed, as Professor Finnane has shown, the mass expulsion of the Melanesians. And so what happens after their expulsion is that the abolition movement, and it's often a protest movement about particular cases, is concentrated on several cases of young Anglo-Celtic men. Widespread public opinion was again mobilised in 1909 with the execution of 21-year-old Arthur Ross, who had been convicted of the murder of a bank clerk in Gayndah. The jury recommended mercy because it had not been premeditated and due to his blameless record beforehand and his youth. And they judged it was not willful murder. And on the gallows, Ross gave a very heartfelt statement, I suppose you could say, through the tears, of his contrition and his remorse. And of course, this case is followed right round Australia, so we know exactly what he said on the gallows. However, he was still executed despite these things, and he was executed under the government led by William Kidston, who is probably Queensland's most maverick, very talented man, but a maverick man, who served with the Liberals. He's later served with Philp. He set up his own party, but also he was the leader of the Labor Party. So you can see this man goes his own way. He's not a team player, and he decides, no, young Ross is going to be executed. Well, a few days before the execution, a large public meeting was held in the Albert Hall in Brisbane, chaired by the progressive Brisbane solicitor Henry Jensen, with Labor MLAs, the Liberal Lord Mayor of Brisbane, Charles Buchanan, and members of the Christian Temperance Union, ministers of religion, and many journalists. Over 400 people were assembled, mostly men. Numerous petitions across the state were presented to the former progressive Liberal Premier who Kidston had been in coalition with, Sir Arthur Morgan, who is now the Lieutenant Governor and President of the Legislative Council, but it was to no avail. Subsequently, an anti-capital punishment league was formed, only to disappear after Ross's execution. I can't find any sort of came. It was there for a week and then it goes. And I think in that situation, I think we can say that this is not an abolition movement per se. What it is a protest against a particular instance. The following year, 1910, the Labor in Politics Convention placed the issue of abolition of capital punishment as 16 on its official platform, and we've already heard what the first things are about the White Australia policy is right at the top. It passed without debate. There were occasional mentions in parliamentary debates by Labor members that they should consider, that it's a Liberal government in at this time, they should consider having abolition, but it goes nowhere. They don't follow any long debate, it's just sort of like a question. The execution of Ernest Austin in September 1913 did not witness any public outcry. And I think, quite frankly, at the time, it was not surprising. He had kidnapped, brutally raped, tortured and killed a little girl of 11 at Stamford. And when he is given the death penalty, given the horrendous nature of the crime, no one, not even the most religious leader, will get up and say anything about the death penalty. And of course, he is the last person executed. At this time, Lucena has left Parliament and he has left Brisbane, so there's no one even to focus any attention on this particular case. There were other Labor advocates of abolition. The more fervent ones were actually outside of the Parliament, and they were journalists on the Worker. And Joseph Silver Collins, who was a great ally of Theodore, and he's one of the people who's on the suicide squad when the upper house is abolished in 1922. Now, when Labor gets in under Ryan in 1915, April 1915, the abolition of capital punishment is way down on the agenda. In fact, doesn't even come on to, not even a blip on the agenda. Why? We're involved in World War I, there's problems about recruiting, the economy, which had relied on the export of primary industries, is completely wrecked. You have rampant inflation and unemployment as well. So I think you could see that it's not going to be a high priority. In the Governor's address in July 1916, placed the issue of abolition as number 14 in intended legislation, and it came after a road to Halifax, the Dental Act, and my favourite one, the Fruit Cases Act. So I think we can see it's not high on the Labor agenda. The bill was introduced on the 8th of September 1916 by the Deputy Minister for Justice, John Fihelli. Now, one might say, I mean, one can smell a rat already in this one. Ryan is Attorney General and he's the Premier. I can tell you, he only makes one sarcastic remark during the whole debate. Dennis Murphy, in his biography of Ryan, doesn't even mention it. So I think we could safely say that Ryan is not putting his efforts in this case. Fihelli's an interesting man. He's the most left-wing of all the Labor members. He is, at this time, extremely upset about what's happened in the Dublin uprising in 1916. And I think in his mind, although we don't know, he doesn't keep a diary, is that he's conflating what happens in Ireland with the poor. He brings up the case of the Kneefs about why we can't have capital punishment, about how dreadfully they were treated. Now, possibly it's poor Irish, you know, as he sees them, heroes, bush heroes against capitalism and all things Anglo that he constantly tells Parliament that he hates. The debate doesn't start well. Fihelli gets up and starts talking, and suddenly the member from Mundubbera, Thomas Foley, interjects while Fihelli is speaking and says, "Vengeance is mine, saith the Lord." He is shushed and told to be quiet. The discussion then goes between Fihelli and, as Peter has shown, between the very able leader of the opposition and of Vowles, who's a solicitor. So, in a sense, it's an unequal. If you read the debate with a clear mind, it's very unequal. Fihelli is not an educated man. He knows absolutely nothing about the law. Not a thing. He might be Assistant Minister for Justice, but he doesn't know anything. So it's all about, we've gone from decapitation, you know, boiling in oil, hang, drawn and quarter, whatever. It's not on the issue itself. It's about how we're going from barbarism to civilisation. Whereas if you read the opposition's case, it is a very clearly argued legal case, and the argument that is used, particularly by Vowles, is that you do have the recommendation for mercy and the prerogative of mercy, and that is always the backup. And the case that Vowles presents, of course, he mentions, although not by name, the 1913 execution of a paedophile and an extremely sadistic killing. So it's like we've got to have a backstop in those sorts of cases. And of course, let's put this into context. September 1916, we've had the Somme, which is the greatest slaughter en masse in a few days in Western history to that time. It's the worst disaster that Australia has faced on the battlefield. And coming up, of course, 16th of October 1916 is the referendum for conscription. So you can see in that sense why Ryan himself, and Theodore doesn't speak either. No senior minister speaks on the abolition proposal, the bill. Now, of course, on party lines, it is passed. There's very little discussion in the newspapers, not surprising. The Somme, conscription, the economy going bust. I mean, I think these at the time would be considered far more important issues. In the upper house, the debate is led by Alfred Hinchcliffe, who had been the socialist leader in the Great Strike of 1891, and he had been appointed to the upper house by the Liberal Premier Arthur Morgan, who wanted to see more diversity in the upper house. It's a very lacklustre performance, I would have to say. He trots through the few arguments because he knows, of course, it's not going to win. So the Reactionary and Obstructionist Council defeats the legislation. The Labor Party really isn't concerned with the issue because it then doesn't come up in the parliamentary Labor Party or in the conventions that occur in the Labor Party. It's sort of just hanging out in the distance. The Parliamentary Labor Party did not pursue the abolition of the death penalty until the upper house was defunct in 1922. So there's no debate between 1916 and 1922, and suddenly it comes on the agenda. The bill was introduced on the 20th of July by Attorney General John Mullen, the member for Charters Towers. Now, though he was not trained in law, he's extraordinarily intelligent and thoughtful, but he leads what is a very lacklustre debate. I'd have to say, in terms of debating, the other side would have won the case. It is again led by Vowles and by the distinguished Oxford-trained barrister Peter McGregor, the member for Merthyr, because they keep to legal arguments rather than, I think, more historical or emotional arguments. Again, the Premier doesn't speak. He doesn't even make a sarcastic aside. So again, I don't think for Theodore it was a burning issue. We don't know. He's not like Sir Samuel Griffith. He didn't keep everything from the age of 4. So we don't have his diaries, letters, private thoughts. However, I do have to tell you that again, there was a bill on fruit packing cases came before this, and it was there was much more enthusiasm about fruit flies at the time than there was about the abolition of capital punishment. When it was abolished, there was very little reaction in the paper. There was a couple of letters to the paper. There's no outpouring of yes or no. So I think it's very instructive for us as historians. Now, as an historian, if I was thinking about this issue, I would immediately in 1916 relate it to what's happening in the war, which of course is never mentioned in any of these debates. In fact, the war isn't mentioned much through 1916. There's other things they're trying to get of industrial legislation and workers' compensation. So, and it shows that sometimes we have to be careful that we don't impose our views entirely back on the past, because I'd have to come to the conclusion, having read all the debates several times and done all the other research, that what this was like was merely an administrative, just trying to change an administrative oversight, and that's all. No great fervour. The fervour after Lucena is gone, and he is alone in great organising petitions, talking about the issue. There's not really. It's a very matter of fact. Well, it's on the books, and we're going to do it. And so, a very instructive, I think, illustration for us now to think about how they thought about it and how we might look. And even of course, we have great admiration for them. But in that sense, I think they would have been quite surprised. The big issue for them was the abolition of the upper house. This was just, I think, merely an afterthought. And on that note, I will leave you.
Thank you very much, Professor Saunders. I think you'd agree that it certainly put some context around the whole issue of abolition and the concerns and perhaps the way in which it happened. And of course, we all like to look at things, we all learn from history, and sometimes we perhaps see what actually isn't there, but we always look to the evidence. And I think you'd agree that this panel has been absolutely amazing in seeking out the evidence and coming to some conclusions about what we now see as a milestone for human rights, but perhaps at the time, given the horrors of the First World War, people had a somewhat different view on it. We might have time for 1, 2 questions, if people are happy. We might have time for one or two questions if people want to make a quick comment, quick question.
Thanks very much. That was terrific. And just, as you say, provided very, very rich context to a remarkable event. But given how remarkable the abolition was in 1922, perhaps to my way of thinking, the more remarkable thing is that the line has been held, as Dean Wells says, ever since. So I was just wondering whether there's been any serious attempt to reopen the issue in Queensland since 1922 in the following decades, or threats to do so. I know, coming from New South Wales, I'm more familiar with the New South Wales experience, but there was a lot of talk about capital punishment in New South Wales in the 1970s and 1980s, the sort of law and order politics, an era of law and order politics, and it would be remarkable in a sense, given Queensland's politics, given the longevity of governments, both Labor and non-Labor. The question is whether there's been any serious attempt to reopen it. No.
Absolutely no.
Nothing.
No.
No threats.
No.
Okay.
There you go, there's an answer. Yes, there's another.
1974, there was a parliamentary select committee into crime and punishment, and there was 2 members of the then government, Mike Ahern and Bill Hewitt, who voted with the Labor members that prevented the select committee coming back with a recommendation that capital punishment should be reintroduced in this parliament.
So that was in the committees? Yes. Right, thank you. Right? I think it's been a very interesting night. I think in a contextual framework, you did what TJ Ryan, a think tank, always does well. Thank you. I know how much work went into that. So can I just say to everybody here, thank you very much for coming. Drinks will now be served and the book launch will be at 7 o'clock. So the drinks and canapes are at the back. You can ask all the questions or chat you would like. And we shall see you back here at 7 for the book launch.